Hey everyone, welcome back to another. The Supreme Court chamber fell silent as Representative Jasmine Crockett rose from her seat at the congressional delegation table. Chief Justice John Roberts had just finished delivering what many perceived as a condescending response to her question about the court's interpretation of the Voting Rights Act. His slight smile and measured tone had carried an unmistakable air of dismissal. Congresswoman Roberts had said, "Perhaps these constitutional nuances are best left to those with extensive experience in constitutional law. The court's jurisprudence on this matter is quite settled." Now Crockett, the former civil rights attorney and Texas legislator, stood with a document in hand, her expression composed but resolute. "Mr. Chief Justice," she began, her voice clear and steady, "before I respond to your characterization, I would like to direct the court's attention to a specific precedent that seems to have been overlooked in your recent decision. What followed wasn't just a rebuttal, it was a precisely articulated legal analysis that would transform the dynamics of the hearing and leave the Chief Justice visibly reassessing the Congresswoman he had attempted to dismiss. Before we examine this remarkable exchange that has constitutional scholars talking, take a moment to like this video and subscribe to our channel for more in-depth coverage of the critical moments shaping America's legal landscape. Representative Jasmine Crockett's path to that Supreme Court chamber had been anything but conventional after earning her law degree from the University of Houston Law Center. She had built a reputation as a formidable civil rights attorney, handling numerous voting rights cases in her native Texas before her election to Congress. Crockett had served in the Texas state legislature, where she gained national attention for her outspoken defense of voting access and her detailed knowledge of election law. What many people didn't fully appreciate about Crockett was the depth of her legal expertise beyond her practice as a civil rights attorney. She had authored scholarly articles on constitutional law and had worked directly on multiple cases that had made their way to federal appellate courts. Her understanding of voting rights jurisprudence was not merely political, it was deeply rooted in practical experience and academic study. Chief Justice John Roberts brought his own formidable background to this encounter, widely regarded as one of the most brilliant legal minds of his generation. Roberts had served as Chief Justice since 2005. Before his appointment to the court, he had argued 39 cases before the Supreme Court as an attorney, winning 25 of them. His reputation for intellectual precision and measured temperament had defined his tenure as Chief Justice. Roberts had long held particular views on voting rights cases as a young lawyer in the Reagan Justice Department. He had advocated for a narrower interpretation of the Voting Rights Act, and this perspective had informed several major decisions during his time on the court. His majority opinion in Shelby County v. Holder had significantly limited the scope of the Voting Rights Act, arguing that the coverage formula in Section 4B was unconstitutional. The congressional oversight hearing that brought these two legal minds together focused on the Supreme Court's recent decision in a case involving Section 2 of the Voting Rights Act. The court's 6-3 ruling had further restricted how the act could be applied to state voting laws, with Roberts writing the majority opinion that established a new, more demanding standard for proving discriminatory effect. Democratic members of Congress had requested this unusual joint hearing of the House Judiciary Committee and Senate Judiciary Committee with members of the Supreme Court to discuss the constitutional reasoning behind several recent decisions. While such hearings were rare, they fell within Congress's oversight responsibilities regarding the federal judiciary. The tension had been building throughout the morning as Democratic representatives questioned the court's conservative majority about their narrowing interpretations of longstanding civil rights protections. Roberts, along with Justices Thomas Alito Gorsuch, Kavanaugh, and Barrett, had calmly defended their decisions as proper constitutional interpretation rather than political judgment. When Representative Crockett's turn for questioning arrived, she had begun by asking about the court's departure from the principle of stare decisis, the adherence to precedent in its recent voting rights decision. Roberts had responded with a slightly dismissive comment about constitutional nuances being best left to those with extensive experience in constitutional law, clearly implying that Crockett lacked such experience. It was this subtle but unmistakable attempt to diminish her expertise that had prompted Crockett to rise from her seat, document in hand, ready to demonstrate that the Chief Justice had significantly underestimated her legal acumen. Mr. Chief Justice Crockett continued standing with poised confidence. I appreciate your concern about constitutional nuances before my election to Congress. I litigated 17 voting rights cases in federal court, including 2 that reached the Fifth Circuit. So I hope you'll indulge my question about these nuances. A murmur ran through the chamber. Roberts's expression remained neutral, but the slight adjustment in his posture suggested he was reassessing the Congresswoman before him. In your majority opinion, Crockett said you wrote that plaintiffs challenging voting laws under section must now demonstrate that the challenge provision approximately caused a disparate impact on minority voters. This represents a significant departure from the court's previous results test established in Thornburg versus Gingles. She opened a legal document, her movements deliberate and precise. However, I'm particularly interested in reconciling this new standard with Justice Scalia's opinion in Chisholm versus ROR, where he explicitly rejected adding additional causation requirements to Section 2, claims Roberts leaned forward slightly. Scalia, the conservative icon, was being cited against the court's new conservative interpretation. An unexpected approach in Chisholm. Crockett, continued Justice Scalia wrote, and I quote, the language of Section 2 does not require a plaintiff to prove causation beyond showing that the challenged voting practice results in a denial or abridgment of the right to vote on account of race. This opinion was joined by 7 justices, including conservatives. She looked directly at Roberts. Your recent majority opinion seems to directly contradict this precedent without explicitly overruling it. Could you explain how the court reconciles these apparently conflicting interpretations of the same statutory text? The question was precisely framed, demonstrating not just knowledge of voting rights cases, but a sophisticated understanding of how precedent functions in constitutional law. Roberts, known for his careful approach to questioning, took a moment before responding. Congresswoman Crockett Chisholm addressed a different aspect of Section 2 than our recent decision. He began the question in Chisholm was whether Section 2 applied to judicial elections at all, not the standard of causation required. Crockett nodded respectfully, but was not deterred. I understand the distinct issues in the cases, Mr. Chief Justice. However, my question pertains specifically to Justice Scalia's reasoning about causation requirements, which was integral to the court's understanding of how Section 2 should be applied, regardless of the specific election type at issue. She turned to another page in her notes. Furthermore, in the subsequent case of League of United Latin American Citizens versus Perry, the court applied the Jingles test without adding approximate cause requirement. Justice Kennedy's opinion specifically noted that the relevant question is whether the plaintiff's opportunity to participate in the political process has been meaningfully reduced, not whether they can establish proximate causation. The precision of her legal citation was impressive even to the assembled justices. Justice Kagan, part of the liberal minority that had dissented in the recent decision, leaned forward with evident interest. Roberts adjusted his approach, recognizing he was engaged with someone who clearly understood the juror's prudence. The court's understanding of statutory interpretation evolves over time. Congresswoman, our recent decision reflects a more textually focused reading of Section 2. Respectfully, Mr. Chief Justice Crockett countered, the text of Section 2 has not changed since the amendments in 1982. What has changed is the composition of the court, not the statutory language Congress enacted. She then pulled out another document. I've reviewed the amicus brief submitted in your recent case. 23 constitutional law professors argued that adding a proximate cause requirement introduces a concept foreign to the statutory text and legislative history of Section 2. Yet the majority opinion does not address this argument. Roberts's court's expression remained composed, but there was a new attentiveness in his gaze. The court considers all arguments presented in amicus briefs, Congresswoman, even when we don't explicitly address each one in the written opinion. Of course, Crockett acknowledged, however, I'm specifically interested in how the court justifies introducing this new requirement without addressing Congress's clear intent in the 1982 amendments to establish a results test that specifically did not require proving intent or causation. She then displayed a piece of legislative history that few in the room expected her to have at her disposal, the Senate report accompanying the 1982 amendments explicitly stated that the ultimate test would be the result, not the intent of the actor Senator Dola Republican, who helped craft the compromise language specifically noted that the amended Section 2 was designed to focus on discriminatory results without requiring plaintiffs to meet heightened causation standards. This level of detailed knowledge about both case law and legislative history demonstrated preparation that went far beyond what Roberts had apparently expected. The Chief Justice took a moment before responding, his initial dismissiveness, now replaced by engagement with a clearly knowledgeable interlocutor, legislative history. While informative is not definitive in our interpretive approach, Roberts said the text remains paramount, and our recent decision reflects the court's understanding of what the statutory text requires. I appreciate the court's textualist approach. Crockett replied, however, the text of Section 2 prohibits voting practices that result in a denial or abridgment of the right to vote. The phrase result in has been consistently interpreted by this court in other contexts as not requiring proximate causation. She pulled out yet another document, in fact, in your majority opinion, in Comcast versus National Association of African American-Owned Media. You yourself wrote that the phrase results in typically imposes a requirement of, but for causation, not proximate cause. That case involves Section 1981, but the interpretive principle would seem applicable to similar language in Section D2 of the Voting Rights Act. This citation of Roberts's own words from a different context represented a particularly effective form of legal argumentation, using the justice's own reasoning against his current position. Several members of the congressional delegation exchanged impressed glances. Roberts, recognizing the strength of this particular argument, shifted to a broader discussion. The voting rights context involves unique considerations about the proper relationship between federal courts and state legislatures in managing elections. Indeed it does, Crockett agreed. Which brings me to my final question, given the court's concern about federalism in this context. How do you reconcile your current approach with Section 5 of the 14th Amendment, which explicitly grants Congress enforcement power to prevent voting discrimination? The Reconstruction Amendments were specifically designed to empower federal intervention when states enacted voting restrictions with discriminatory effects. Principles of statutory interpretation and constitutional theory. When the committee chairman indicated that Crockett's time had expired, Roberts did something unusual rather than simply letting the exchange end. He addressed a final comment directly to her Congresswoman. I appreciate your thoughtful engagement with our recent decision. While we may disagree on the conclusions, your analysis reflects the kind of substantive legal reasoning that advances our constitutional dialogue. These are complex issues on which reasonable legal minds can differ, coming from the typically reserved Chief Justice. This represented a remarkable acknowledgement of Crockett's legal abilities. Several legal observers in the room recognized it as Roberts' way of publicly correcting his initial mischaracterization of her expertise. As questioning moved to other members of Congress, the tenor of the hearing had been fundamentally altered. Subsequent exchanges seemed almost anticlimactic after the substantive constitutional debate between Roberts and Crockett. During a brief recess, Justice Elena Kagan approached Crockett, though their conversation wasn't publicly audible. Those nearby reported that Kagan expressed appreciation for Crockett's precise legal arguments and deep knowledge of voting rights jurisprudence. When the hearing resumed, even the Republican members of the committee engaged with Crockett, differently addressing her, with the deference typically reserved for recognized legal experts, rather than treating her primarily as a partisan figure. By the conclusion of the eager hearing, what had begun as an attempt to diminish Crockett's standing had instead elevated her reputation significantly. The Chief Justice's initial dismissiveness had provided the perfect backdrop against which her genuine legal brilliance could be displayed not through assertions or credentials, but through the substance and precision of her analysis. After Mazur-Au's session adjourned, legal journalists who had attended the hearing were already filing stories with headlines like "Former Civil Rights Attorney Schools," "Chief Justice on Voting Rights Precedents," and "Crockett's Constitutional Expertise Shines in Supreme Court Confrontation." What might have been a routine oversight hearing had become a notable moment in the ongoing dialogue between the legislative and judicial branches about the future of voting rights protection. The exchange between Representative Jasmine Crockett and Chief Justice John Roberts reverberated far beyond the Supreme Court chamber. Within hours, clips of their legal debate had spread across legal blogs, news sites, and social media platforms, generating millions of views and extensive commentary from constitutional scholars. Legal experts from across the ideological spectrum acknowledged the substantive nature of the exchange. Harvard law professor Lawrence Tribe tweeted, "Regardless of where you stand on the merits, today's exchange between Reppers Crockett and C.J. Roberts represented constitutional dialogue at its best, precise, substantive, and focused on interpretation rather than politics." Conservative legal scholar Orrin Kerr noted, "What made Crockett's questioning so effective wasn't partisan framing, but her mastery of precedent, including conservative opinions that seemed at odds with the court's current approach. That's how you engage seriously with the court's jurisprudence."